My face Okay dah, it's done. Ready.
Broadcasting.
Yep, already.
Okay, can I have the score sheet, please? Does anyone have an Android charger?
Charger.
Yeah. And then there's someone who's applying my battery. I don't want it. Score sheet. All right, welcome everyone to round 2. My name is Ron. I'm the chair of this round. In government, we have FISSKB. In op, we have DJ Tan Bloody Oblivious. All right, sure. Who is replying for Gov? Aiman. All right, without further ado on the motion that we would ban out-of-court settlements, I'll invite the Prime Minister here. Oh, wait, who's that? Oh.
Is it 4?
Alright.
Alright.
Elves. Okay.
Into this debate, we see how there's a trend that out of court a form of pending lawsuit. So we believe that these forms of out of court settlement is really problematic. Therefore, we from the government side would like to ban this form of settlement. So our stance from government side into this debate is very simple. We believe that we want to ban out of court settlement because there is a need for judicial intervention in any form of crime within the court. So basically, the reason why we want to first ban out-of-court settlement is because we see problems within the status quo. We see when out-of-court settlement happens, and wait, before I start, I want to define what is out-of-court settlement. So out-of-court settlement is a form of, basically out-of-court settlement is a form of agreement which is done outside the court during a pending lawsuit without any form of judicial intervention. So this is what out-of-court settlement is. So basically, why government side into this debate would like to ban this form of settlement, because we believe when this form of settlements or agreements happen outside the court without any form of judicial intervention, the credibility of the agreement achieved during the settlement or during the discourse between these two parties can be doubted, because the definition of out-of-court settlement itself already show how it happens without any form of judicial intervention. Because we believe the reason why judicial intervention is there is to give a proper form of punishment to those who deem to be necessary. So that's the reason why the judicial court is supposed to be there. So the problem with out-of-court settlement is that the credibility of the agreement can be doubted, and second, we do not know how this form of in these out-of-court settlements. So how are we going to ban these forms of out-of-court settlement, right? So we believe during a pending lawsuit, when there is a form of out of court settlement or an agreement reached between two parties which satisfy both sides without any form of judicial intervention, we believe any form of out of court settlement being brought upon the court wouldn't be accepted, and these two parties at the end of the day will be judged, will be in a proper trial at the end of the day, right? Therefore, these criminals or whoever deemed to be necessary will receive a proportionate amount of punishment at the end of the day. So yes.
So, I don't think our court settlement means what you're trying to talk about. It means like, if let's say a husband and wife splits up and the husband wants a dog and they decide to do it out of court, that's an out of court settlement. They're not criminals.
First, it's not only husbands and wife who go to the court. Anyone or any form of criminal, any form of crime can be of the day, right? So I believe that I answered your well at the end of the day. So moving on to my first point, under the key phrase of there is a need for authority intervention within any form of criminals, right? So the first reason why there is a need for authorities intervention at the end of the day, first, we believe that talking about society in any nation, there is a form of social contract between the government and the citizens. So what do we mean by social contracts is this? We believe that talking about social contracts, people within the society already agreed to limit certain sort of autonomy by granting the government right to set and enforce law. Therefore, by setting and enforcing law, they can protect the society. Therefore, society will be safe from danger. So we talk to you, we argue to you with the existence of out of court settlement. Like I've told you before, the decisions can be doubted by the court itself, by anyone who viewed the this form of out of court settlement. Sorry, not now. And we believe that the reason when this form of achievement can be doubted, moreover, we believe that we don't know first, because we don't know how they discuss and achieve any form of agreement, right? We don't know if it's done in any form of improper way. We don't know if any form problematic. So we believe that with the existence, sorry, not now, if the existence of out of court settlement, we see that for a criminal to be free from the trial without any form of this form of agreement. We don't know how they achieve this form of agreement. Sorry, not now. We don't see how they achieve any form of agreement. Therefore, we believe when these particular parties or out of court settlement being brought up upon the court and it is accepted at the end of the day, we believe that the probability for any criminals to not be punished will be high. Therefore, if this happens, if this happens, it will portray a really bad image of the judiciary court at the end of the day, right? So second and third reason why there is a need for authorities intervention in any form of criminals, right? Because first, we believe that it is necessary. Secondly, we believe the existence of court a proportionate form of punishment upon the criminals.
Yes. I don't get your case. If there's a problem and someone committed a crime, the victim will bring the case to court anyways.
So this is the problem. That's the problem. To achieve an agreement any form of judicial intervention, that's the problem, because these people, he committed crime, but somehow at the end of the day he or she managed to find an agreement that fulfill this both side mutual satisfaction out of court upon the court. Therefore, this particular criminals, the probability for him or her to be free from punishment, really bad image of the judicial court. That's really problematic. We're talking about proportionality of forces. We believe the existence of court. We believe this form of criminals will be punished proportionate. I believe that this is really good, because we believe criminals should be punished, and we believe that it cannot be happen simply out of court settlement is there. Any form of criminals can be free from any form of punishment. I believe that single criminals that exist deserve to be punished, deserve a proportionate amount of punishment at the end of the day. So with that, what I've been telling you in the past several minutes is this: that out of court settlement is really problematic. Why? First, because criminals have the propensity for them to escape or to be free from any form of punishment, whereby they are supposed to be punished portrait of the judicial court. And with that, I'm very proud to propose.
All right, thank you very much. very much. To start the clash of this debate, I'd like to invite the leader of the opposition. Here.
This debate was never regarding crimes that are severe crimes like murder or rape. These are the kind of crimes in this context which involve cases like divorce, enforces cases within corporations and another corporations. We think that they really got this entire wrong by running very truistic argument that only say that you should be charged because you are a criminal. We think that's a truism. We don't think it was legitimate in the first place, because we think that they got this entire characterization wrong. These are issues, once again, that only pertains minor issues, which we are going to clarify to you. We're going to have three arguments for you today. Firstly, how their policy is an choice. Secondly, how their policy brings about unnecessary cases to court. And thirdly, how their policy subjects people to unnecessary. At a few direct rebuttals. Firstly, they talk about how every single crime has to be settled. Number one, we think that in their context, it's a federal persecution. We're not talking about very severe cases. We don't think that murder can be settled between two mutual consensus, right? We think that individual naturally want to charge the person that actually killed their loved one. But secondly, they talk about this problem on credibility of agreement and how no intervention will be given. Number one, we think that credibility is not a problem in our case, because we think that in all these kind of minor issues, people should decide that for themselves. But secondly, out of court settlements are used for people who feel that there's no need for court, like minor cases in which both parties want to get at least satisfaction or the harm mitigated as much as possible. So we don't think their policy actually stands today. We do have rebuttals, but
for any form of harsh criminals, suddenly both parties achieve an out-of-court settlement.
What? You have to think logically. Like if my loved one is being murdered, I wouldn't say that, okay, I'll let you free. Like, these are minor cases. Like, I don't get your entire POI. But on the first argument, on the infringement of individual choice, on the first level, we think that people's perception of justice is different, because we think that in status quo, the reason why out-of-court cases is because someone to maintain an equal consensus, by agreements that they agree that, sure, both parties, maybe you should get this, maybe you should get that. And because this happens because people have different idea of justice, we think that under their policy that never happens. But on the second level, we think that their policy forces people to go to court. Why? Because we think that when there's no leeway to allow actually an out-of-court decision to be settled, you force people to go to court and face any kind of unproportionality that happens in court. Because the individual have to regardless whether they agree with it or whether they do not agree with it. We think that's very problematic when you force individuals to go to court. On the third level, we think it's extremely harmful when courts would subject an individual to an unnecessary both parties that maybe would not result to that much amount of harm if both of them agree on a mutual consensus. We think that the court makes them go into those kind of harm in which it harms both parties. We think that is a very severe harm. And on the fourth level, we think that in cases like divorce or disagreements between two corporations, we think that if you follow their policy, it further harms the relationship. Even if they do want to get some equal and mutual consensus, under their policy, what they do is force people to go to court. We think it's very problematic because the results affect both parties. And secondly, on cases in which you have children sit down, you have children involved in those kind of cases, we think that the burden is even worse, because we think that if any party, like for example, their father lose in a severe court case, we think that the amount of money lost is even worse, and you destroy that relationship between those two parties. So we think that those are the kind of harms their side brings upon us. But secondly, how their side brings upon unnecessary cases to court. Because we think that on the first level, courts have to focus on more important issues. We have to understand that courts are extremely important and have to focus more on important cases, not irrelevant cases. When courts would exaggerate and make a specific case more severe, it looks like that case is extremely severe, but it's actually not, because the corporation that the focus of the court shifts. It shifts between focusing on that particular case or this particular exaggerated case. We think it's extremely harmful, but for the ability of the courts to function properly and perfectly. And when exaggeration occurs under their side, when there's no opt-out system, we think that chances of losing a case without exaggerating would be higher, because we think that less exaggeration would also mean you would more often. We think that it's very harmful for another party, because we think that in court it's all about winning. It's all about people go to the extent in which they exaggerate just to win a specific kind of case. We think that that's very problematic under their side, which doesn't provide an opt-out system. On the third level, we think that fairness is easier on out of court, because it's decided by the people involved. Because we think that when both parties reach mutual consensus, it wouldn't be like both parties will lose traumatically. We think that both parties will obviously say that, look, this is where we draw the line between both parties. This is where we agree on certain kind of cases. We think that when both parties do agree on a specific issue, we think it's much better, because not only one party will lose traumatically. In our context, can actually mitigate the amount of harm that can be incurred among two parties itself. We think on the outside that's better. On the third argument, which is why the outside is subjecting people to unnecessary harm. On the first level, we think that lots of cases can be settled outside courts, like cases do settlement, like for example, which parents can visit their child more. Those kind of cases can be actually settled outside of court. It's between a mutual agreement between a father and a mother. We think that their side doesn't allow that, because people would always have to go to courts. Because we think that sure, both sides, people naturally want to receive closure as much as possible, but their side doesn't allow that. Because when court fully decides what your closure should be, when courts fully decide what your punishment should be, it's way worse, because we think that both sides can't even reach a mutual consensus. It's way worse. On the third level, we think that it harms individuals when they are forced to testify in court. We give you an example of emotional damage to an individual when they're forced to testify something, even if they don't want to. Because we have to know that in court, when you testify, you have to testify against a jury, you have to testify in front of a crowd. We think that some individuals don't want to expose those kind of intrinsic harm that happen among them to the general public. We think that under their side, when they force individuals to go to court, it's way worse for individuals itself. For all those reasons, we are very proud to oppose.
Thank you very much. To continue the case outside government, I'd like to invite the Deputy Prime Minister.
Mr. Speaker, we believe that justice should be served in the first place. And if they want to argue about this debate should be about minor cases, fine, we will debate about it, Mr. Speaker. But yeah, maybe agreeing to the fact, even if that these severe cases will not be settled out of court, Mr. Speaker. But we believe that these minor cases that they want to debate about should also be brought to court. Why? Because when talking about these minor cases, talking about divorce cases, Mr. Speaker, you don't want an illegitimate result to happen out of court, Mr. Speaker. That you want to bring these cases to court in order for details and to investigate about these cases, Mr. Speaker, in order to have a proper solution, in order to have a proper result at the end of the day, Mr. Speaker. And even if they were, moving on to the rebuttals, right? Their case is all about the first argument is about the infringement of individual choice, Mr. Speaker. And we believe that these individuals, when going to court, that these individuals have the rights to speak up and to defend themselves, Mr. Speaker. And we believe that by having the rights to speak up, Mr. Speaker, no, sorry, sit down, that this is enough for the jury to know, and therefore that the jury will decide it under the law, Mr. Speaker. Because when talking about juries, Mr. Speaker, you're talking about people who understand the laws properly, Mr. Speaker, who are being educated about the laws in a particular place. Therefore, we need to send these minor cases to court in order to have a proper result, and even if they want to talk about mutual satisfaction, Mr. Speaker, and we cannot guarantee that this mutual satisfaction is actually legitimate at the end of the day, Mr. Speaker. Yes.
The problem with your case is representing themselves within the court. The individual choice we're talking about is people don't want to subject themselves to the harms of the court.
Speaker, if they don't want to subject themselves to the court, Mr. Speaker, then fine, because we believe that these minor cases, people who want to bring they have the choice, because of we're banning this out of court settlement, Mr. Speaker. I believe even if they want to make a settlement out of court, we don't agree that they can make a settlement out of court. But we believe that if they want to make a settlement, then they need to make it properly. If they don't want to make a settlement in the court, Mr. Speaker, that is what we believe in, Mr. Speaker. No, sorry, sit down. Okay, moving on. They also talk about how these minor cases, how these unnecessary cases will shift the focus of court, Mr. Speaker. And we believe that basically you have courts that settle minor cases, and you have courts that settle severe cases, Mr. Speaker. And we believe that it doesn't really shift the whole focus of court, in the first place, Mr. Speaker, because we have courts who play its role in order to settle these minor cases in the first place. Okay, then they also talk about how it forces them to go to court, Mr. Speaker. Yeah, of course, because it is necessary for them to go to court in order to know what is right and what is wrong, Mr. Speaker. Because if they want to make their own decisions, that we believe that there is a possibility of them making irrational decisions. That is why we want to hand this power to the authority, to the people who deserve to solution in order to have the best case scenario, Mr. Speaker. Yes.
One of you need to characterize what is the illegitimate outcome of these settlements.
Okay, Mr. Speaker, talk about illegitimate outcome. Okay, we're talking about how divorce cases, right? When talking about the rights for these parents, to have their to take care of their child, Mr. Speaker. Okay, we're talking about these cases that there should be a proportional. There should be a proportional outcome when if these cases are being brought to court, that a proportional outcome will be achieved at the end of the day. Therefore, that we are serving justice, because if they want to make an out of court settlement, Mr. Speaker, that we believe that there's a possibility of them making irrational decisions and making them think that they have a mutual satisfaction, but the fact is that is one side will one side will obtain more interest compared to the other side without making the other side know about it, Mr. Speaker. And that is illegitimate from our paradigm, Mr. Speaker. And that is why we believe that these cases should be brought to court. Okay, we're on to the first point, right? How the possibility of justice being served is less. Yeah, just like I told you how we're talking about when there's no judicial intervention, how these people would not know which one is right and which one is wrong, which decision is right and which decision is wrong, Mr. Speaker. Therefore, that even minor cases should be brought to court. Should be brought to court in order for them to know whether which one is right and which one is wrong, and at the end of the day, a proper result, a proper outcome, a proper solution will be achieved. Yes.
Okay. A McDonald's employee spilled coffee on a woman's shirt. Okay, her shirt is now ruined, and she wants to replace that shirt. Do you think that you want to force her to go to court just to get that settlement?
Mr. Speaker, those kind of cases are not, no, those kind of cases that you know that what are the things that you should do, Mr. Speaker. We believe that these are the things that you don't need to be brought to court. But cases such as minor cases such as you want to argue whether which one should be whether which one should win, Mr. Speaker. That is why we believe that is when the case should be brought to court in order to have a proper solution done by the jury who are very educational about the law in that particular place, Mr. Speaker. With all those reasons, Mr. Speaker, I believe that justice should be served by banning off-court settlements. Thank you.
Thank you very much. Now we invite the Deputy Leader of the Opposition to continue Ops case.
A frivolous lawsuit is a lawsuit that is so mundane and so irrelevant when it comes to actual law that it doesn't even, that people try to dismiss these cases, right? Or people try to, or even the judges themselves will look at these cases and say, no, we're not going to do this law at all, or try to look at this case at all. What is a frivolous lawsuit? And this is something that actually happened in McDonald's a few years ago, right? A woman who received her coffee, right? The coffee was hot and she spilled the coffee on herself, right? And this is the funniest part, is that she used this as an excuse to blame McDonald's and say, right, McDonald's now needs to pay me a settlement so that I'll bring you to court for that. Now, this is the type of things that will increase under your paradigm, because what happens now, essentially all the small settlements that you would have seen, let's say I actually bumper-ended your car, and it's a lot easier for both of us for me to just pay you that sum of money so you can fix your car, instead of bringing you all the way to civil court saying that, oh yeah, this is the settlement that I need to fix my car here, so I need to bring you all the way there. We think it's extremely harmful in that sense. When there are two parties, right, who already have a consensus of achieve from using this out-of-court settlement, right? And this is something that was never understood by their case in itself. Because what did they bring up to us in the first place? They told us, oh, these people are criminals. These people are doing the ones that are harmful things. But this isn't actually what it is, right? What happens is that out-of-court settlements usually happen for civil cases, right? Or if they were brought to court, it would be about a civil case, right? Where people, let's say you bumper under your car and things like that. Now, we think that's extremely more efficient, right? And this is something that brought up by Kenneth already, and they never responded to, by the way. It's more efficient for these people to handle these cases themselves. Because what happens if you do force them to go to court and not have the out-of-court settlement? It's essentially all the small things that you will see in life, right? And probably you will meet. Let's say a dog tore, let's say, a part of your lawn up, and you want your neighbor to repay you in some way. Do you think that you need to hire a lawyer and tell this lawyer that, yes, this is what my neighbor did, and then both of you have to go to court, and battle it out? We think this is extremely harmful towards whatever that you want to do and your justice in the first place, right? But before I go into my idea of increase of frivolous lawsuits and how the first place, let's talk about their first premise, right? That, forcing people to go to courts is essentially more justified, right? Because there are juries there who know about the law in itself. But what they don't understand is how these type of settlements actually happen. What happens is that two parties, right, if let's say they do want to do a settlement, will probably talk to each other, sometimes with lawyers, sometimes without, right? But essentially, these people can only come to that agreement when both sides agree. If one side feels that it's not being taken seriously or even given the most money or settlement that it wants, it can always choose to bring that person to court. We think that's fine. But there's a difference between forcing every single person to going to court, and this is where we want to come in, right? Because it's not really justice if you tell us that, oh yeah, you have to go to court to determine what that justice is. Sometimes people view their justice as something that's different, right? Sometimes they think it's a lot easier to have that money and, instead of going all the way to court and spending that money as well, right? Or sometimes justice doesn't have to be given out by the jury themselves. Because sometimes I understand people themselves want
other things different from just that settlement of money. Maybe you want a written statement towards them, or maybe some gift, right? We think that all these things are essentially helpful towards the justice system itself and towards the court case itself. Okay, so now going into my first substantive, right, about frivolous lawsuits, and this is something that's extremely important, which they will never understand apparently. Because what actually happens in today is that these people, right, these people who are actually doing these out-of-court settlements are people who generally don't need to go all the way to court to determine what is the value that are being lost or what they want to earn, right? Because you only go to courts when either one, you don't get the best end of the stick or you don't get what you think you deserve. Actually being wrong in that sense, and your right is being infringed upon, right? We think that when your right is being, like, when both sides agree to give each other that agreement, right, or to pay off each other, we think it's extremely fine in this sense. Because if you don't do this, right, essentially all the small mundane things that wouldn't have existed in court in the first place, right, and these are things like, oh, you know, being in an accident, actually just destroying a part of your lawn, and these are the type of things that people do need a little bit of money or something from that person who ruined your lawn, let's say, to help you and refurbish your lawn. But the problem is, right, why we don't think that you need to force these people to go to court? Because it's a lot easier for you and your partner to deal with this by yourself, right? We don't think that it's okay to tell people that, yes, you know, if you do want to get that money to refurbish your lawn, you have to go all the way to court. It's a lot faster and it's a lot easier when two people can do this by themselves, right? And it also saves the court system time, and this is something that I want to point out in them as well, right? Because their justice is never absolute, right? And this is extremely important because there exists guilty plea bargains, right? Where you do reduce the sentence of that person already if that person just says that, yes, you know, I'm guilty, I'm willing to go to jail for it. This really shows that it's not really absolute justice in that sense, and people don't actually want, and the government itself doesn't actually want absolute justice. Sometimes you need to take into account the efficiency of these court cases, right, and whether you need to concentrate on the more important things in life or just go through more and more frivolous lawsuits that we don't want to do, right? So the conclusion to this argument is this: one, you essentially force more frivolous lawsuits onto these courts themselves, but two, you essentially make sure that these people have to spend a lot more money getting lawyers and building up cases against each other just to get a small form of settlement that they could have done without it, right? And what happens now is that settlements are naturally fair in itself that comes out, right? And this is something that is also clashing upon their case, right? Because what happens if someone doesn't feel like they have the right end of the bargain, they'll obviously go to court. This shows that, you know, if there actually is that form of unfairness there, that people will actually go to court. So it's fine anyway, right? The mutual exclusivity here is that you also need to understand that you don't need to go to court to be fair, right? And that some people view justice as something like that doesn't need to be meted out by the jury or the judge itself. You need to understand that sometimes people feel like they're okay with just receiving a little amount of money, or maybe receiving something else, like that person helping them move their furniture or something like that, right? We think that these kind of things can happen outside of courts itself, right? And we don't want to allow these people to go into courts and necessarily slow down and take away the concentration onto its more important issues that can happen in civil courts itself. Side with side prop.
Thank you. Before I invite the next speech, can we please applause before and after speeches? All right. Thank you very much to the DLO. Now, to start the first week speech of this debate, I'd like to invite the government with.
A very good evening, I bid to all. So I am the speaker from the government side. Totally proposed to this motion simply because there is a need for judicial intervention in the courts. there is a need for judicial intervention. So I will divide my speech to 2 points. First is to rebut what have the opposition side had said, and second is to clarify our case in the government side. So I start with the opposition. First, they had said that about that we, the government, are forcing people to the court. But here it is. We are not forcing. It is because that we believe that it could bring much more betterment in order to settle things that happen. It could be plus the crime that happened. It could and then it could bring a much more better result. Plus, please, I just start my speech. How could you ensure? Okay, let's say that how could you ensure that the credibility of doing the out of court settlement, the credibility of the agreement. Okay, as an example, as we kept talking about divorce in this session, so I take that as an example. Okay, let's say that this husband and wife, they want to divorce, and then they want to they want to take the children, and how to who are going to take care of the children. But then there is a possibility during the agreement is being formed. There is a possibility that the mentality of maybe the wife or the husband is not very stable, or they just divorce. And then how could you ensure that they could bring a much more justification, much more better results in the out of court settlement? Because because there is possibilities that maybe that they have a unstable mentality. What is this? I am divorcing. Who I am going to give these children? So in the end, actually it will bring harm to the one who do the out of court settlement. Different from if we bring this kind of matter to the court. If we bring this matter to the court, the people could be justified. No, you should give these children to this husband or maybe this wife. So because the other people that are going to justify this kind of cases, they have much more stable mentality and they know what is the best. That's why we must bring cases to the court. Okay. So and then I proceed on that the opposition had said that does this mean that all kind of crime, including the minor cases, is needed to bring to the court? Does that will solve the problem? Well, you see this. Even the the opposition had said that something like they said that destroy the law, and then they want money so the things could be settled by just give money and to repair things. The two people could settle it, no need to bring this kind of minor crime to the court. But there is a possibilities. Maybe that could happen a trade. There could be a happen trade that let's say person A and person B. Person A had somehow destroy the land like the opposition said, and then the person A said, okay, I will give you the money. Here, give me, take the money. So we settled. But then there is possibilities that the person B is traded. Oh, you must give me much more money. This is not enough. There is much money is needed to settle it and so on. So it is much more better to bring to the court so that the court could the way of solving the problem, a much more better solving the problem, and then there would be kind of case that treating and so on. So and this is focus shift harm to the police, this is people involved, such a necessary harm court fully decide session. Oh, okay, and the opposition said that they don't want to if we bring people to this court, we will testify them, and they don't want to expose their more harm. That is what I get from the first speaker said. And then just if a crime is needed to settle at the court, so that it isn't going to bring harm, because the things is going to be settled much more better. It won't bring like this person bring much more danger to the person. So if they don't want to expose themselves to the court, they don't want to to the court. So how could their crime could be settled? Even if they do the what you call that? Out of court settlement, it's still not it will still not resolve the problem. So now I move on to summarize what my previous speaker has said. They said that about there is a need of authority intervention, and then we also have said about the people don't know which is right and which is wrong, and we are from the government side stand up this case under the stance of there is a need for judicial intervention. So with that, I beg to post.
Thank you very much. Now to end constructive speeches for this debate, I'd like to invite the opposition.
Out-of-court settlements are necessary when one, there are instances where people didn't think a court was necessary for their case. But secondly, when mutual reconciliation towards both parties to bring satisfaction to both parties, we don't think there's a problem. So our government set up a case that is extremely truistic, whereby there is no actual change within status quo. But secondly, we also think it's not mutually exclusive, because if you want crimes to be prosecuted, those things can happen outside. But what is exclusive is you don't even want to give people a choice towards not going through the afflictions and the harms that can bring them, because within a court case, we think that's very harmful. Two issues into this debate. Number one, the role of courts and why it's problematic under their side in instances where people didn't want a court case. But secondly, what's better for individual choices and people in general. On my first issue, number one, we think that their characterization of court cases is simple, that judge intervention is necessary because they make the best decision. Sure, we concede when you want crime prosecution, those things are necessary. We think that in the context of big crimes, then there's always law to mitigate the kind of out-of-court settlement that you want. But secondly, if the law isn't in place, people will naturally want to prosecute those people anyways, because they don't want to get out of the law, and they necessarily want their justice to be served. But even if we go with government's characterization of how the criminal is able to for out-of-court case settlement, we don't think that will happen, because families, members, and other people within their surrounding can stop those from happening. But secondly, even if it succeeds and these criminals are able to somehow persuade the victims, we think that there's no problem there. Because if the people consent to having out-of-court case settlement, that means that the people in some cases agree that it is better for that person itself, and we think that's better for them to have their choices. But secondly, it also means that satisfaction was accorded the justice that he thought was necessary within the out-of-court case settlement, and that's way better for them, because their perception of justice was at least upheld. But on the second idea on justice, right, because we have to understand that people have different interpretations of justice. So if out-of-court settlement was their interpretation of justice, we don't think there's a problem. But secondly, what did they say about it? They said that they wanted legitimate choices and courts, we don't really understand it, right? Because proportionality doesn't exist under their side, and we'll prove to you why. Because we think proportionality is way better under our side, because both parties have to agree to the outcome of the out-of-court case settlement. So if they don't agree, they will naturally go to court. But secondly, their side, where you always force people to go to court, and we have to understand the nature of courts and why it's not proportionate. Because in a court case, it's always a win or lose basis, right? So both parties who have to present a case towards the court, they have to necessarily present a case that is in assuming to want to win that case. So that means that the losing party within that circumstance will always lose disproportionately, and we think that's very harmful. Because at least in the out-of-court case settlement, gives a disproportionate harm towards the losing party, and we don't think that's proportionality. But fourthly, we also think that justice is hindered under their side, because there are always going to be people who never want to subject to a court. That's when you give leeway of escape for people to escape from the justice system, right? Court, and the losing one because they didn't want to go to court. Out of court case settlement couldn't happen in this circumstance, right? Before I move on, yes.
Doesn't that mutual satisfaction could be legitimate, because we believe that just when going to court, that justice should be upheld regardless whether it satisfies both parties.
But when it comes to disputes, sometimes there is no right and wrong in this situation. What courts do is courts force a right or wrong within that circumstances. So it's very disproportionate when the losing party has to lose disproportionately towards what the court perceive is justice, right? We think justice is want to be perceived by people. We have no problem with that. But let's move on to my second issue on what's better for individuals. We argued to you that the choice was very important, because a lot of cases where companies would like to have a formal discourse out of court cases, and it's extremely important for them because they wanted to avoid the affliction of the court. But their response to that was, if people wanted to avoid the court, then don't go to court. Then that's exactly contradictory towards their case when they wanted justice so much in the first place. Because if you didn't want people to go to court when it's a small matter, at least have an out of court case settlement. That's when also think more importantly, so that they have the most autonomy in their case, they can control the outcome and also the process within those situations. That's where can they reach the most satisfaction, right? But we also allow them to decide what's fair for them and not let the courts intervene in this circumstance, especially when it's a minor dispute. But secondly, why is it harmful to subject people to the affliction of court? Something that they want to engage on, right? We think that a lot of situations where people fear court cases for the harms of having to testify to a certain situation. Those things are harmful because you cause emotional pain towards people, something that they didn't want to engage on at all. We think those are the reasons why you can never subject people to a court case. But secondly, if these people opt out, it's even more harmful for them to never accord to the justice that they necessarily deserve in this instance, right? We think out of court case settlement at least provides them that leeway to get the justice they deserve. But secondly, we also think that courts harm individual relationships that my Prime Minister brought to you about. No responses to that. So what he meant was, in the certain cases of divorce, out of court cases, at least when you allow that dispute to be not just exaggerated within the harms, right? So when you bring it to a court, those things have to be exaggerated, and this is why people fear to go to courts, right? But secondly, you also cause disparage within that relationship, which is harmful, because you disallow for the condition to people want to have within their relation when the court intervenes and makes it even worse, right? But secondly, when it talks about children, the whip talked about children, we think that that's even worse under their side, because go through a court and let a court decide the fate of the family. That's even more harmful for the children who didn't necessarily want it. We think an out of court settlement could have been better for the family, because then their relationship wouldn't be harmed in that circumstance. So after that better relationship within the both people, when they settled it properly and mutually and not let a court intervene. We think a lot of problems come out when you bring up minor cases to courts, because you force people to then present a case against each other. It's no longer reaching mutual consensus. It's no longer about having discourse to what's best for both individuals. In fact, a spillover of harms, like the people in your company or your parent or your children in this circumstance. That's when you force courts to have to decide what's necessarily fair for you, and we don't think that's what people's interpretation of fairness is. So under our side, we at least allow people to have that choice to decide, both parties mutually, that yes, we want an out of court case settlement, that yes, we think justice can be reached. But even if justice is not reached properly within our side, at least we still have a court to back them up. But under your side, you have to force people to always to go to court, and that's necessarily harmful because they didn't want to have and consent to that choice. But secondly, if they don't want to go to court, court, they didn't know go to court, they at least don't have an out-of-court case settlement to then help them accord to those justice. We think those circumstances are harmful, so go with side opposition.
Thank you very much. Can we have the first of reply speech?
Yeah. Side government's case was only about punishment, punishment, and punishment. They never proved their burden today. They are supposed to prove to us why out-of-court settlements are harmful. They never did that, Mr. Speaker. All they have did is prove about punishment again and again. The idea how their side causes unnecessary harm to individuals. Secondly, how they prevent unnecessary case in courts. And thirdly, how when exaggeration happens, it becomes way worse. They never engage about that. All they want to talk about is punishment, punishment, and punishment, and truistic arguments about punishing criminals, which really prove to you that it still happens in status quo. What we are trying to solve are minor problems. So we think that their side really lost track in today's debate. We have two questions for you today. Firstly, which side's model is better? And secondly, which side understands the very humanity of individuals? But let's look at the first question. Which model is better? The side government keep coming up and telling you that they need a judicial intervention, like as if it doesn't happen in status quo. We've told you that firstly, severe cases are already charged under federal law, but secondly, we told you again and again that some kind of minor cases can be simply settled outside courts, like Yongsheng's example on the McDonald's issue, and our example on divorce cases where they don't want the courts to actually determine how much they can actually see their children, in which they never really engage on. We don't think that. But secondly, they also talk about how authority has the right to punish individuals, and they want to promote proportionality. One, we have already told you that it's not proportional when individuals are forced to go to court, because even if they can settle the problem outside of court, their side forces individuals to use the court because there's no such thing as an out-of-court settlement. But secondly, their side is more unproportionate because punishment can severely affect both parties, even though both parties want to settle these kind of issues outside court, when they want to mitigate the amount of harm that can happen towards them, in which they never really talked about. We have told you why our side can prevent unnecessary cases to be brought into court, because on and certain issues less. We think that under their side, it makes unnecessary cases go to court even more. But secondly, we have also told you why people can decide what is more severe, because we think that if people think that that severe case is really severe, then they can go to court and settle it inside court. But if they feel that the problem isn't that severe, if it's causes pertaining to divorce, for example, if they feel they can solve it on their own, under our paradigm, we give them leeway to solve on their own. But on our second question, it is which side truly understands the very humanity of individuals, which they've neglected and shouldn't away this entire idea that come from outside. We think that their side, firstly, don't give a choice to individuals because they are forcing people to relieve traumatic experience by testifying in court. But secondly, their side never respects individuals' right to human dignity, because we tell you that if they don't want to testify in court, if they don't want to relive those kind of traumatic experience, we think that they have a right to do so. On the outside, we have told you why outside necessary harm, because we think that if there are problems that can be settled outside courts, as long as both parties agree to whatever they want, we think that is more justice and proportionality, but they don't give a leeway for people to get the proportionate punishment they want. To testify in court really causes intrinsic harm to the children itself, to relive those kind of traumatic experience. We think that their side never understood the very humanity of individuals. For all those reasons, our side takes today's debate.
All right, thank you very much. Now for the last speech of this debate, I'd like to invite Ika to reply.
Mr. Speaker, when the Prime Minister over there told the House that we have never clarified to the House the harms of the out-of-court settlement. But it's really problematic because in my speech, I've already told you that how criminals have the probability of not getting any form of proper punishment, and we believe this will portray a really bad image of the judicial court at the end of the day, right? So that's the really problem of the out of court settlement itself, because we believe if that happens, it will hamper the process of criminal and justice system itself, because in criminal justice system we believe deterrence is there. If these things happen, we believe deterrence is not there, and we believe that the number of crimes at the end of the day will increase, and it's not impossible, right? So moving on to, so what I'm going to do in my reply speech today is very simple, because I'm going to tell you the problem of their side. I'm going to sum up our case in today's debate, right? So I'm going to tell you my first part of speech is this, whereby under their paradigm, they keep on talking about the problem of the court, right? Whereby they told the House that how within court itself that people keep on exaggerating, right? Mr. Speaker, the idea of exaggeration, I mean, in any court, exaggeration happens. I mean, you cannot avoid exaggeration. So we believe that that's why within court, the one who is the this jury will have a proper form of discourse between other jury and decide which side win this case or not. Doesn't matter how bad they exaggerate the case or not, right? So that's the idea of so that's to tackle on the idea of exaggeration. The second, they told the House how this form of out of court settlement only implies on minor cases, right? We told you it doesn't matter whether the case is minor or severe, right? Because we believe even if it is minor, we believe that it can become severe, because we believe in the process of achieving out of court settlement, we believe during the process a new form of dispute can happen. We believe that we believe that a new form of force between people can happen. We believe that it's not impossible for these two parties to fight between each other, and this is really problematic. Therefore, in order to form of minor cases towards the court at the end of the day, right? So how by going into our case, it forced people to go to court. So our question is this: so what's wrong with forcing people to go to court? Because they failed to clarify to the House what the harm of going to court itself. Because they only told the House when we force people to go to the court, first it will shift the focus of the court, and second it will waste time of the court system itself. We believe that that's wrong. That is problematic, because we believe that in Malaysia itself, we believe many types of court that will settle with minor cases and severe cases, right? Which means this form of cases will go to this form of court, and we believe this form of problem will not happen. So that's the problem. That's taken on their case. So to sum up our case, right, we told you that out of court settlement is really problematic. Why? Because there is a probability for these people, for these criminals to escape from any form of proper punishment. And we believe that this is really problematic. Why? Because it will portray a really bad image of the judicial system, and this form of criminal justice system cannot function or cannot operate.
Alright, thank you very much. Please cross floor, shake hands, wait outside. I'll call you back in once I finish.